Hello, you're watching Addleshaw Goddard's Employment Channel. Today's programme focuses on reinstatement and re-engagement orders made by employment tribunals when an employer loses a claim for unfair dismissal. To recap, a reinstatement order requires the employer to treat the employee in all respects as if they'd never been dismissed, and a re-engagement order requires an employer, its successor or an associated employer to re-engage the employee on comparable terms to the job from which they were dismissed or in other suitable employment. Although these types of orders are rare, it seems that more employers are requesting them if they've won their claim for unfair dismissal, not least because of the current financial situation in the UK, making it harder than ever for employees to find suitable employment. Lena Amati, an employment law barrister at 9 St John Street Chambers, talks us through her experiences of reinstatement and re-engagement orders and why it's so important for employers involved in unfair dismissal claims to be aware of them.
Today we're going to be talking about reinstatement and re-engagement orders, and in particular I'm going to be looking at the rules surrounding the circumstances in which these orders are made and the factors that the tribunal take into account when deciding whether or not to make a reinstatement or re-engagement order. Now, often re-engagement and reinstatement orders are overlooked, and this is particularly because historically they've always been quite rare, and that still remains the case. However, in the current economic and employment market, you can see that there is an increase in the number of claimants seeking re-engagement or reinstatement as part of their compensation in unfair dismissal claims. So whilst they are still rare orders to be made, it's important for employers and lawyers alike to be aware of the circumstances in which they're made and the factors which the tribunal take into account when deciding to make them. The Employment Tribunal Rules of Procedure make it clear that reinstatement and re-engagement are important remedies which are available to the claimant, and one of the ways in which they do that is by requiring that a tribunal explain to a claimant where an unfair dismissal claim has been held to be well founded, that they may seek an order for reinstatement or re-engagement. You've heard a little bit from Liz about what reinstatement is, but to recap, reinstatement is an order that the respondent treat the claimant as if they had never been dismissed. And essentially that means that the employee comes back to work on the same and certainly not less favourable terms than which they had been employed on before the dismissal had taken effect. And in deciding whether or not to make an order for reinstatement, the tribunal will firstly consider the claimant's wishes, but also whether it's practicable for the respondent to comply with the order. The third factor that the tribunal will consider in deciding whether or not to make an order for reinstatement is where the claimant has caused or contributed to their dismissal, whether it would be just to order reinstatement. Moving on to re-engagement, that is an order that the claimant be engaged in employment with the respondent or an associated employer or a successor in employment on comparable terms. Now obviously that offers the tribunal a degree of flexibility that is not available in reinstatement orders. And it's important to note that where a tribunal is asked to consider reinstatement and they decide not to make an order for such, they are obliged to consider whether re-engagement would be an appropriate order to make. Re-engagement is the type of order which has a much more significant impact on larger companies or groups of companies that have multiple branches, particularly because the tribunal is looking at associated employers, successors, and also whether the employee can be employed in comparable terms. The factors that the tribunal have to consider in whether to make an order for re-engagement are very similar to that which they consider in orders for reinstatement. Namely, they will consider the claimant's wishes, but they will consider whether it's practicable for the respondent to comply with the order, but also whether it's practicable for an associated employer or successor to comply with the order. And finally, in considering whether it's just to make an order for a re-engagement where the employee has caused or contributed or contributed to their dismissal, the tribunal will consider what terms it is just to order reinstatement on. So there and again, you're seeing that there is a level of flexibility in a re-engagement order that is not available on reinstatement, and particularly in the context of where an unfair dismissal claim has been found to be well-founded, but the employee has contributed, or there is a genuine redundancy situation. In re-engagement, the tribunal is, for example, able to re-engage the employee in a lower position to that they had been employed, or to reflect their contribution in the terms in which they are re-engaged. Now, for both reinstatement and re-engagement orders, there are financial consequences which flow, and particularly the tribunal will make an order for a pay of arrears which have accrued between the date of dismissal and the date in which the reinstatement or re-engagement order would have been made. And like in any unfair dismissal compensation claim, that will include the benefits that the employee would have been entitled to but for the dismissal, including pensions and other contractual benefits. One thing that it's noteworthy to pay attention to is the fact that there is no upper limit to the amount of arrears in pay that can be made between the date of dismissal and the date of a reinstatement and re-engagement order, and that again is a factor which employees have to be mindful of, particularly where they're dealing with highly paid employees who have had a significant period of time between the date of their dismissal and the issue of remedy coming before the tribunal. Obviously, both in reinstatement and re-engagement orders, the employee's continuity of service is preserved. Now, the two factors which are continually raised in issues of re-engagement and reinstatement are practicability and contribution. Now, dealing first with impracticability, it's for the respondent to prove that it's not practical for the employee to be re-engaged or reinstated. And particularly, it's for the respondent to provide the evidence and the materials upon which they rely upon at the remedy hearing to prove that, if that's their case. And obviously, the burden of proof is heavier on larger businesses with multiple branches, because they are then engaged in deciding whether it's practical to not only engage the employee in their place of work prior to dismissal, but also any other branches that they have or any other associated businesses. Another factor which often comes up is the effect of a replacement on the question of impracticability. Now, the fact that an employee has been replaced isn't in itself sufficient to prove that it's not practicable for them to be re-engaged or reinstated, and the tribunal will have regard for the circumstances of each particular case and including the size of the employer, the number of employees who are doing the type of work that the employee did prior to dismissal. There are two circumstances where the existence of a replacement will show that it's impracticable for an employee to be re-engaged or reinstated. The first of which is where the respondent is able to prove that it was not practicable for the work to be done without engaging a permanent replacement. The second is where a reasonable time has lapsed and the claimant has not indicated that they wanted reinstatement or re-engagement. The second issue which I mentioned earlier is contribution and its effect on whether or not an order for reinstatement or re-engagement will be made. Now, inevitably, given that these orders are very rare, contribution will be a factor which the tribunal will have heavily on their mind in deciding whether or not it is just to make an order for reinstatement or re-engagement. That being said, it's important that employers, and particularly larger employers, are able to show that the particular cause of contribution to the dismissal makes it unjust for that person to be re-employed, and it shouldn't be taken as a given. That's a matter which should be dealt in a witness statement when one is produced to deal with the issue of remedy. To summarise, there are a number of factors which the Tribunal will consider when deciding whether to re-engage or reinstate an employee, but it's important as the employer to firstly ensure that they're prepared to deal with that issue at a remedy hearing, and particularly to deal with the issue of whether or not the claimant has been dismissed and whether it was necessary to have a permanent replacement, whether or not the claimant has contributed to their dismissal and the impact that has on their suitability to continue in the respondent's employment, whether or not that claimant is going to have contact with individuals who have been involved in the events leading up to the dismissal, and in particular the effect that their re-engagement or reinstatement might have on employee relations, and finally whether or not that respondent or any associated employer or successor has any vacancies available, and what practical steps would need to be taken to accommodate the claimant in re-employment if that was ordered by the Tribunal.
Thanks, Lena. It's worth bearing in mind that if an employer fails to comply with an order for reinstatement or re-engagement, the Tribunal will make an additional award of compensation of between 26 and 52 weeks' pay. Although a week's pay for these purposes is capped, it still represents a significant amount for any employer. If you have any queries at all in relation to this topic, please do not hesitate to contact us, either through your usual Addleshaw Goddard contact or by clicking on the Contact Us box to the right of the screen. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.